discuss today. Senator Durbin and I have worked together on a number of initiatives. I don't think any is more important than confronting the scourge of child sexual exploitation, or CSAM. You know, that's an anodyne-sounding abbreviation. But as I hope everybody in the room appreciates, and those who are listening online understand, that abbreviation stands in for a terrifying, horrifying reality. We're talking about, in a word, child pornography. We're talking about child sexual exploitation, child sexual abuse. The amount of this material online, available online, is truly astounding, and we're going to talk about that over the course of today's hearing. But of course, these aren't just statistics. Every single instance of CSAM online represents a real child, a real person who has been tragically and oftentimes life-alteringly abused. And it's the conviction of myself, and I know Senator Durbin, and I hope every member of not just this subcommittee, but the entire Senate Judiciary Committee, that we have to do something about this. We've talked about it for years. The time to take definitive action is here, and that's why the legislative framework that we are discussing today, I think, is so incredibly important. But let me just give you a sense of the scope of the problem that we're talking about. Worldwide, 302 million children have been victims of child sexual abuse material and child sexual exploitation online. Let me say that again. Worldwide, 302 million children. 300 million children globally have been subjected to online solicitation. Solicitation, that is, for some sort of sexual abuse or following some sort of sexual abuse. To give you another angle on the scope of this problem, when an online platform becomes aware of instances of child sexual exploitation, under our law, they're required to report those instances to the National Center for Missing and Exploited Children, NCMEC, their cyber tip line, and we're delighted to have the CEO of NCMEC with us today. But just consider this data. In 2014, the number of reported instances of online child sexual exploitation in 2014 was 1.1 million. Now, that's a staggering number, but consider where it is today. In 2023, the year for which we have the most recent full data, that number was 36.2 million. 1.1 million in 2014, 36.2 million reports of online child sexual exploitation in 2023. And the number of urgent reports, those are cases where the child is thought to be at present risk. You might say clear and present danger. That number has grown by 140% in just the last 3 years. If you think about the images themselves, the poster behind me gives you some sense of this. Back in 2004, there were 450,000 images reported online of child sexual abuse material. Again, that number in itself is huge. Nothing like what we're seeing today. The number today tops 104 million known reported images of child sexual abuse online. This is truly a crisis. It is an epidemic. And it's not a theory. It affects far too many children in the United States of America, to say nothing of the, as we've seen, hundreds of millions of children worldwide. So the question is, what are we going to do about it? And that's what we're here to talk about today. Senator Durbin and I, in the last Congress, introduced what I believe is truly landmark legislation, which I might add passed the Senate Judiciary Committee in what is nothing short of a miracle by a unanimous vote. This legislation would protect child victims and witnesses in courts with new rights, new safeguards, new procedures. It would expand the scope of restitution provisions in current law. It would enhance the cyber tip line. It would create a child online protection board to allow parents and victims to go and argue their case, to have material taken down and to receive restitution. And for my money, maybe most importantly, it would allow victims, finally, to have their day in court. It would allow victims to get into court and to bring suit against online platforms that are hosting this material and making money on it. Which brings me to the culpability of big tech. You know, big tech has said for years, oh, we're doing all we can, but we know, because we've heard the testimony from folks who have sat right where our distinguished witnesses are sitting today. We've heard the testimony of parents who have gone to the big tech companies, have reported instances of child sexual abuse material online, including victims who reported their own abuse material. I was abused. These are my images online. Please take them down. The big tech companies often will fob them off on some complicated procedure that never bears any fruit, or just flat out refuse to do anything. And I'll never forget the testimony of one mother who sat right there at that table and said, when I told this tech company, it was Snapchat in that instance, when I told them about the sexual abuse material that was online, they just laughed at me and said, there's nothing that you can do. You can't sue us. Well, ladies and gentlemen, it's time to change that. It is time to allow victims to have their day in court. One of the most important foundational rights that we have as Americans is the right to get into court, to get in front of a jury, and to vindicate the personal rights given to us by our Constitution, by our systems of law, by our system of laws, and dare I say, by nature and nature's God. And that right is currently denied to parents and victims in this country. You can't sue these platforms. They're protected by congressional legislation. It's time to change that. This bill would finally allow victims to have their day in court. And guess what? The big tech companies absolutely hate it. They despise it, which is how you know it's a good idea. In fact, it's how you know it's essential. Listen, I will never forget watching the FTC some years ago fine Facebook at the time. I think it was $1 billion. Maybe it was even more than that. What happened to Facebook's stock price the next day? It went up. They didn't care. Did they change their behavior? No. Did they do anything different? No. They just plowed straight ahead. But you know what these tech companies fear? They fear accountability before a jury of their peers. They fear a courtroom. They don't want to be accountable in court. They don't want victims. They don't want parents to have the right to sue them in an open court. They don't want to be held liable civilly, fairly. They don't want to be subject to due process. It is time to make them subject. It is time to impose civil liability. It's time to give victims this right. And that is what this bill would do, among the other important procedural safeguards and reforms that I mentioned just a moment ago. I want to thank everybody who's here in attendance. We have so many folks here from child protection organizations, so many of you who work in this field, who are literally in the trenches every day protecting children. Thank you for your incredible work, and thank you to our incredible witnesses who have joined us today. It's truly an all-star panel. And now let me introduce the witnesses. When Senator Durbin gets here, when the witnesses are finished, we'll allow him to make a statement. But let me introduce our witnesses, and then we'll have the opportunity to hear from each of them. We have Michelle DeLon, who is the President and Chief Executive Officer of the National Center for Missing and Exploited Children. She previously served 8 years as NCMEC's Chief Operating Officer. We're delighted to have you, Ms. DeLon. We've got John Tanago, who is the Executive Director of the International Justice Mission's Center to End Online Sexual Exploitation of Children. The center protects children in the Philippines, where nearly 500,000 children are sexually abused in order to produce this online CSAM material. This happens especially through live streaming, and I think Mr. Tanago will testify to that effect today. We have Gregory Schiller, who is the CEO of the Child Rescue Coalition. This is a nonprofit organization that rescues children from sexual abuse by building technology for law enforcement to identify and arrest and prosecute child predators. Thank you, Mr. Schiller, for being here. Taylor Sines, who is a survivor advocate. We're so glad to have you, Taylor. Specifically, Taylor is a survivor of internet-facilitated online enticement, child sexual exploitation, and CSAM. Her case was one of the largest online enticement, sextortion cases prosecuted at the time, with over 300 victims. 300 victims of the convicted perpetrator. And we have John Pizarro, who is the CEO and co-founder of Raven, a firm that focuses on legislative and policy solutions for child trafficking and child exploitation. Previously, John spent 25 years in the New Jersey State Police conducting, managing, and leading investigations in terrorism and organized crime, narcotics trafficking, and child exploitation. He spent his last 6 years as the Internet Crimes Against Children Commander. Now it's the custom of this committee and subcommittee to swear in our witnesses when they appear. So if I could ask each of you to rise and to raise your right hand, and then we'll get started. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Fantastic, Mr. Pizarro. Thank you again to all of our witnesses. Let's start the questioning. And Mr. Tanago, I want to start with something that you said about these companies in your experience. You said that they often complain that it's just too expensive to take any sort of enforcement action or deterrence action. Could you just elaborate on that? I mean, what's been your experience when working with these major platforms that often are hosting the streaming that you were talking about, for example?
Well, the quote that I referenced comes from Julie Inman Grant, Australia's e-safety commissioner. And thankfully, Australia has had a robust Online Safety Act and regulatory powers for several years now. And so e-safety has been engaging with tech companies to understand what are they doing to address CSAM, what are they not doing. I think one of the most powerful things was in 2022 when e-safety published summaries of transparency notice responses. And specific to the question of what were companies doing to address live stream child sexual abuse, almost all of them said nothing. They weren't detecting it, they weren't disrupting it, they weren't reporting it. And I think that quote comes from her continual engagement with these companies to try to understand why. Why would you ever look the other way when there's an active crime scene happening on your platform, through your services, and you have the technology to detect it in real time? And so apparently what she has been told is it's too expensive, which tells me that their priorities are absolutely backwards.
What a great way to put it. They are absolutely backwards. And I want to just highlight what you said there, that the companies complain frequently that, oh, it's just too expensive for us. They're not disrupting, they're not detecting, they're not deterring. And yet, in 2023, Meta had a profit, not revenues, profits, $23 billion. Google, $60 billion in profits in 1 year. Apple, $97 billion in profits. Amazon, $27 billion in profits. So don't tell me that they don't have the wherewithal financially to disrupt, detect, and report. They absolutely do. The truth is, they don't want to do it. And right now, they're really not compelled to do it. I want to show everybody a picture of a young girl. This is a profile of what is a young woman who's clearly underage. You can just hold it up, guys. Let's have a look at this. So here is what appears to be the picture of a young girl whose birthday, by the way, indicated that she was a minor. Now, the thing about this girl is it's fake. The New Mexico Attorney General created this profile as part of that office's investigation into the behavior of these online platforms. So they create a profile with a date of birth that clearly indicates she is a minor, she is underage. And what does she get from this Facebook profile? What does she get? She was immediately barraged with friend requests from men between the ages of 18 to 40. Request after request uses sexually aggressive languages. This account received numerous sexually explicit chat messages each week, often with images, sexually explicit images from the men who were messaging her. The account received an offer to be a sugar baby for $5,000 a week. The account was added to a chat group focused on cultivating young girls between the ages of 12 and 16 for sexual exploitation. And get this, this girl was also, this profile was also served up Instagram video content featuring other young girls between the ages of 13 and 16. Meaning what? Meaning that Facebook's own algorithm knew she was underage, knew that there was sexual exploitation and sexually suggestive messages happening back and forth. The algorithm knew that and served up additional sexually exploitative content. The girl was also served an Instagram advertisement for a law firm representing trafficking survivors. The ultimate irony. Now, of course, if this girl had really existed, could she have brought suit against Facebook? Not a chance. The law currently prevents it. And yet, Facebook's own algorithm, they own Instagram, Facebook's own algorithm recognizes her as underage, recognizes the child sexual abuse content going on, recognizes that she may be a victim of child sexual abuse, and therefore sends her referrals for attorneys who work in this space. What should that tell us? Their algorithms are absolutely capable of identifying potentially sexually abusive material, totally capable of identifying when there's potential grooming going on, and yet they say, Mr. Tanoga, as you said, they say all the time, oh, we just don't have the resources to do it. In fact, what they want to do is monetize people like this They benefit currently financially from sexual exploitation. And this is why it is so important. It is so important to allow victims, actual victims. Thank goodness this girl doesn't exist. But there are literally millions like her, as you know from your own experience, Ms. Sines, millions like her who are being exploited, sadly, as we sit here today in this committee room, who feel as if they have no recourse. And sadly, under our current law, they have very little recourse. It's time to give victims like this the right to get into court. Ms. DeLund, can I just ask you, you have so much experience in this area. In your view, what is the role that the technology platforms, the online platforms, what role do they have in deterring and disrupting and reporting this kind of abuse? And why is it important to require them to do more than they currently are?
Thank you. It's interesting. I think as you were talking also about what we learned from the Australian E-Safety Commissioner, it goes to also a provision within the Stop CSAM Act about transparency reports. We're spending a lot of time trying to identify where there's a decrease in reports, what happened. So much we have learned from what they're telling us from Australia is something that we would be able to take out. The transparency. What are these companies doing that is allowing this to happen? Are they detecting? Are they reporting? Where are they getting their information? How long are they holding? What types of reports are they getting from victims, from the public? At this point, we don't know. It's actually remarkable how much we do know when you consider this is entirely voluntary. Besides when there is a known violation of a parent-child pornography, sex trafficking, or online enticement, at that point it triggers a report. Other than that, this is all just based on relationships and meeting the right person and finding out what they're doing. It's not going to work any longer. We're seeing that. The voluntary structure of how the companies are making decisions without any sort of transparency, so we understand what they're doing and what they're not doing, it won't last any longer. We're seeing the drops, and at this point, more companies, we're talking about the drop in reports, more companies can simply make different business choices, the reports will go away, the incidents are not going away. We're just being blinded to them.
And that's why it's so important that we strengthen these reporting requirements as we
Absolutely, absolutely. One of the examples that I have in the testimony was regarding two offenders who were ganging up on a young girl, forcing her to produce awful, horrific child sexual abuse content. We sent that report to law enforcement. We called out this weekend to find out what happened. You had two law enforcement agencies in 2 states serving multiple subpoenas, exigent subpoenas, trying to find that victim. Can't find the victim and don't know what happened because enough information was not provided at the moment they made that report. We need more details. If a report has been triggered, we need more details so law enforcement can actually protect children.
I think we've got Senator Britt is on the way, so let me just ask another question or two while we wait for her to arrive. Mr. Schiller, if I could just come back to you. My understanding is that the Child Rescue Coalition plays a major role in developing new technology that can be used against online CSAM. Can you speak to that?
I certainly can, Senator. Thank you. Yeah, for the better part of 10 years now, the Child Rescue Coalition generates software for law enforcement for free so that it can expedite their work in combating child exploitation between peer-to-peer networks, live streaming technology, and everything else that's out there where our children are at risk. The technology gives law enforcement the opportunity to proactively go after these individuals, incredibly streamlining their process and minimizing the work they have to do. The beautiful thing about the technology is it works hand in hand with every other law enforcement technology to combat child exploitation. So when law enforcement receives a cyber tip from NCMEC, they will also run that information against information from the Child Rescue Coalition to see if offenders are in different places and make a robust and really wholesome investigation against the offender.
Very good. Thank you for your terrific work, and thank you for your senator's work. Ms. Sines, can I just come back to you? I want to pick up something that you said in your opening statement about when your exploiter created all of those profiles in order to post all of that material. And you said that Facebook said to you initially that they would not take down so many of these different profiles. How long did it take before you were finally able to get this content, and these profiles, which were generated, as I understand it, with the sole purpose of embarrassing you, shaming you? How long did it take to get Facebook to finally take those down?
Thank you, Senator. At first, it took a little over a day. until we were able to hone in on a personnel that we could directly contact at Facebook. And then any other time there were postings, we would contact that one specific personnel and they would be taken down within a few hours. But at first it was a day, maybe longer.
Well, I think one of the important things that this bill does additionally is it creates a reporting mechanism for victims, an independent board, because what we've seen all too often with the companies, and this was your experience, is that people will go to them, report it, and oftentimes the companies, they drag their feet or they do nothing. They do nothing at all. And they say, well, you know, too bad. This bill creates an independent board that is able to receive these complaints, review them, and then order that this kind of material is taken down within 48 hours. And also to subject companies that violate this order to fines, including some restitution for victims. So your experience, again, is so instructive in this regard. Thank you for being willing to be here and to share it with us, and thank you for your courage. Britt, thank you for your leadership on this. Mr. Pizzaro, I think maybe you have summed it up well. These companies, this is a business model. They want kids online. They want to sell them stuff. They want, let's be honest, they want the child exploiters online also because they benefit from their business. This is really about profit at the end of the day, and until it is not profitable for these companies to host this abusive material online, they're going to keep doing it. Until it is not profitable for them to evade the reporting requirements, they're going to keep evading them. They're not going to be good actors until we force them to do it. And that's why the legislation we've been talking about today and the other issues that we've been considering, age verification, et cetera, is so vital, because we do need to protect our kids. We do need to put power back into the hands of parents and victims. And I'll just end with this. To me, this is the age-old American story. Who's going to have the power? Is it going to be these mega corporations who are not accountable to anybody, or is it going to be the people? Is it going to be the victims? Is it going to be the parents? Who's going to have the power here? This technology can work beautifully if victims and parents actually have power. Right now they don't. We need to give it to them. I want to thank again the ranking member for his tremendous work on this. I said, Senator Durbin, when you were out of the room, I really said a lot of nice things about you, Senator Durbin, so maybe we'll leave it there.
I'll check the transcript.
Thank you all for being here. Thank you for the witnesses for being here today, for your testimony, for your work. Thank you to the many advocates who are here in the room. And with that, this hearing is adjourned.